judiciary values. For some time, there has been some problem when it comes to disciplinary proceedings against judges. These proceedings are also administrative in nature, but there were some decisions of the Supreme Court saying that the quantum of proof should be proof beyond reasonable doubt. So you had that earlier case of Lakindanom, I think decided way back in 2005, where the Supreme Court said that administrative proceedings against judges are highly penal in nature, and therefore they must be substantiated by proof beyond reasonable doubt. This has been repeated every now and then, and as a matter of fact, a week after that case of Lakindanom, in a case involving a sheriff, the court also made reference to the same line of reasoning, thus making it appear that those in the judiciary would now be subjected to a higher quantum of proof for their dismissal or some other disciplinary proceedings. In 2008 or 7, the case of Alquizar versus Carpio, the case involving sexual harassment against a judge, the Supreme Court again made reference to proof beyond reasonable doubt as a necessary quantum in order that the disciplinary action, especially the more serious ones, could be successfully prosecuted against a judge. I think it was in August of 2007. In December of that year, the Supreme Court also decided another sexual harassment charge against a judge, the case of Tan versus Pacoribol. That case was assigned to a justice of the Court of Appeals to investigate and make recommendations. So after hearing, the investigating justice came up with her recommendation, and she said that it was duly proven the alleged acts of sexual harassment, and therefore the judge should be dismissed. In the recommendation of the investigating justice, she made reference to the quantum of proof as was mentioned by the court in the case of Alquizar versus Carpio, namely proof beyond reasonable doubt. What is, however, interesting is that when the Supreme Court decided the case, even as it reproduced the recommendation of the investigating justice, it did not make reference to proof beyond reasonable doubt as the quantum necessary. It merely made reference in the body of its decision, that in administrative proceedings, all that is required is substantial evidence. Then last year, in the case of Macias versus Macias, by the way, what's the cutoff? December of 2010? In the case of Macias versus Macias, the Supreme Court, in one of its divisions, and in a decision penned by Justice Natura, clarified this issue. The court observed that there's been some inconsistency insofar as the Supreme Court is concerned when it comes to what is really required as quantum of proof. So it came up with the observation that subsequent cases have now abandoned the requirement that there be proof beyond reasonable doubt. The only problem with that is it was by a division. So it could not be said that it was now clearly abandoning what was stated earlier in the earlier decisions. Just like in the case of back wages for government employees. What is the prevailing rule in regard to back wages for illegally dismissed government employees? Before Republic Act 6715, so far as the private sector is concerned, you had the so-called 3-year back wages rule, isn't it? The maximum amount would be for 3 years straight, without deductions or additions. Then came 6715, in which the law now provided for full back wages. How about for the government sector? What was the rule? Am I asking too much? There used to be that 5-year back wages rule. But subsequently, the Supreme Court came up with decisions which now say full back wages. The problem is, those decisions did not specifically abandon the 5-year back wages rule. So last year, I think September or August, the Supreme Court came up with a decision which reaffirmed the 5-year back wages rule. Anyway, perhaps I would never ask that in the bar. If they do, then perhaps you can also make reference to the fact that the Supreme Court has said every now and then full back wages, but there are also some other decisions which require the 5-year back wages rule. So that's the problem with the Supreme Court at times. Perhaps because of the volume of cases that they decide, there is some problem coordinating. But insofar as Masias is concerned, and insofar as Justice Natura is concerned, he has already clarified that when it comes to administrative cases against judges, all that you need would be substantial evidence. While it is true that judges are held to higher accountability, according to him, it does not necessarily mean that they should also be subjected to higher quantum of proof for purposes of disciplining them. Because they are still, just like any other government employee, accountable officers. And therefore, what obtains for other government employees and officials must also similarly obtain with regard to those in the judiciary. When it comes to academic disciplinary proceedings, you also have the student's right to due process. So we have that old case of Guzman versus National University, where the Supreme Court said that the guarantee of procedural due process for students would include the right to be informed of the charges and the right of the students to answer those charges. Then the evidence against the students must be produced, and the students in turn would be given a chance to produce or introduce their own evidence. The Supreme Court also noted here that the proceedings are summary. Therefore, there is no right of the student to cross-examine the witnesses that may be presented against them. In the case of the Lasal University, the Supreme Court here took note of the proportionality between offense and penalty. What was the incident here was embalming of a student. The Lasal investigated and found the student's charge guilty. It imposed the penalty of expulsion. The Supreme Court said the penalty of expulsion does not appear to be proportionate to the offense. Therefore, there should only be exclusion. They sound the same, right? The court said if the penalty is disproportionate to the offense, then there would be an issue of due process. So it would be more like substantive due process. So, what's the difference between expulsion and exclusion? Technically, the Supreme Court explained, when it comes to expulsion, the student is kicked out from school and is no longer allowed to enroll elsewhere. When it comes to exclusion, the student is also kicked out, but he is still given a chance to enroll in some other institutions. So in this particular case, there was a bowling incident which lasted only for a few seconds and which did not result in any serious injuries. Accordingly, the court said it would be too much to now permanently prevent the students involved from gaining an academic degree because of that incident. It's enough that they are kicked out of LaSalle, but it would be too much that they should not be allowed to finish any degree through the penalty of expulsion. So they should only be excluded. When it comes to employee dismissal, of course you are familiar with the requirement, which is both procedural and substantive. Procedural, you have the 2 notice requirement, and substantive, that the dismissal must be based on just or authorized cause. When it comes to the 2 notice requirement, the first one is to inform the employee of the intention of the employer to terminate his or her services on account of certain acts, and for which that employee should explain why he or she should not be dismissed. And the second notice would already be the embodiment of the decision of the employer to do away with the services of the employee. When it comes to the substantive basis for dismissal, take note of the recent case of Formantes versus Duncan Pharmaceuticals. He was investigated by his employer because of certain complaints against him, particularly in regard to sexual harassment. And he was eventually dismissed by the employer for insubordination. When the case went to the arbiter the employer was charged with illegal dismissal. The employer was able to substantiate the alleged act of the employee of sexual harassment. So, what was the basis of the labor arbiter in upholding the dismissal was different from what was alleged in his dismissal. He was charged with insubordination and he was dismissed. When he filed the case for illegal dismissal, he was found to be guilty of sexual harassment. So, is that valid? The ground which was used to uphold his dismissal was different from what was the basis given by the employer in terminating his services. The Supreme Court said, yes, that's still valid, because before the labor arbiter, the employer was able to substantiate the fact that he was guilty of sexual harassment. Now let's talk about people acting like lawyers. Strange people. In the case of Romagos versus Metro Cebu, Water District. Romagos was dismissed on account of mental incapacity. The Supreme Court explained that mental incapacity could arise from vicious conduct or other immoral conduct, in which case dismissal would be a disciplinary proceeding. However, if it is merely mental incapacity not arising from those, it could still be a basis for dismissal, but not as a disciplinary proceeding. Instead, it would be in accordance with the responsibility of the Civil Service Commission to maintain merit and fitness in the workplace or in civil service. In this case, Romagos was dismissed merely for mental incapacity because she exhibited signs of mental disorder. But even in cases of dismissal on account of mental incapacity, not as a disciplinary proceeding, the Supreme Court said the employee is still entitled to the guarantee of due process. Why is that? In order to avoid the use of this ground as a means by which the employer may do away with employees that the employer doesn't want. So, in that regard, the Supreme Court said there must be a showing that that employee had been exhibiting this kind of behavior for some time already. Excuse me. And it must also be shown to have been observed by his superior as well as his fellow employees. Then, the employee must be notified in writing that the employer intends to do away with that employee's services on account of mental incapacity. The employee would then be given a chance to explain or rebut the charge, and finally, a notice would have to be given to the employee by the employer about the termination of her services. In this particular case, the Supreme Court said that the employer was able to follow the procedural requirements. However, there was a problem with the substantive aspect. While it is true that the employee had been displaying or exhibiting this behavior for some time, as a matter of fact, she really had some depression and she underwent professional help. At the time when she was dismissed, the court said she was already cured of her problem. There was already a certification coming from her doctor that she was now fit to return to work. Accordingly, the Supreme Court said there was illegal dismissal. And perhaps just to convince everyone that there is basis for reinstatement, the Supreme Court said from the time that she was initially observed to be exhibiting this behavior to the time when she was dismissed, she was able to obtain a masteral degree. So if an employee could have a masteral degree in the meantime, then it could only mean that she was no longer suffering from mental incapacity. And in this case, the Supreme Court made reference to the amount of back wages, which was full instead of merely limiting it to 5 years. So for that purpose, it made reference to two earlier decisions of the Supreme Court, also making reference to 5 or to full back wages, or back wages from the time of dismissal to reinstatement. But if you again go to those two earlier decisions, the Supreme Court was not that explicit that it was abandoning the 5-year back wages rule insofar as government employees are concerned. Now let's talk about elementary due process. We have that case of Olivas. The Olivas here is General Prospero Olivas. He used to head the Metrocom until Marcos left Malacanang. So just like General Ramos, he also had to step down. And just like General Ramos, he was soon haunted by allegations that he allegedly amassed unexplained wealth. So just like General Ramos, he was also charged before the Ombudsman. Then the Ombudsman required General Ramos to submit his counter affidavit. General Olivas. General Olivas, who happens to be a lawyer, perhaps knew the law better than most. He said, "How could you require me to submit my counter affidavit when you have not yet furnished me any affidavit?" The Ombudsman said, "It's okay. Anyway, the charges against you are detailed enough. So you can very well prepare a counter affidavit based on the charges specified in the complaint." General Olivas said, "No, I won't." So the case went up to the Supreme Court, and the Supreme Court agreed with General Olivas. The Supreme Court said a counter affidavit is supposed to reply to counter a previous affidavit. So you cannot require someone to file a counter affidavit if you have not yet furnished him any affidavit that he's supposed to be answering or rebutting. It's only common sense, isn't it? When it comes to law, of course, it's difficult to determine if there's such a thing as common sense. In the subsequent case of Bautista versus Sandigan Bayan, Bautista was also charged before the Ombudsman, and eventually an information was filed against him before Sandigan Bayan. While his case was still in the Sandigan Bayan, or in the Ombudsman, he was asked to submit his counter affidavit without an affidavit having been previously furnished him. He did as was required of him, and the Ombudsman found probable cause to charge him before the Sandigan Bayan. Before the Sandigan Bayan, he now claimed the benefits of the Olivas doctrine. So according to him, since he was not previously given an affidavit before he was required to submit his counter affidavit, then the Olivas doctrine should apply to him. The Supreme Court said, it's now too late for you to invoke the Olivas doctrine. When you were asked to submit, you readily did so. Therefore, it's now too late. The Ombudsman has already found probable cause, and as a matter of fact, there is now a pending case before Sandigan Bayan. Therefore, you can no longer benefit from the Olivas doctrine. Now let's talk about legs. The case of Civil Service Commission versus Lucas, we have here an incident about legs, which assumed a constitutional dimension. I think part of the increasing trend towards a woman's world is the fact that more and more the women are depriving the men the opportunity to appreciate their legs. Right? And in time, you might just see the converse. It could now be the men showing their legs and the women wearing the pants. So how did an incident involving legs take on a constitutional dimension? Lucas was a government employee. He was charged by a female co-employee of having touched her legs. So if your hands are not welcome, then that's an offense, right? But if they are welcome and you withhold your hand, that would also be an offense. In this case, the hand was not welcome. Lucas was asked to explain. He did. According to him, he was trying to reach his shoes. And when he bent down, that's the time that he accidentally brushed the legs of the female employee. So would you believe that? Of course, the office did not believe him. So it imposed upon him the penalty of 1 month and 1 day of suspension. Lucas still claimed that he was innocent. He appealed to the Civil Service Commission, and the Civil Service Commission found him guilty of grave misconduct and dismissed him. So Lucas again had to go up, this time to the Court of Appeals, and the Court of Appeals said, okay, we agree with you. You should only be penalized with suspension. This time, it was the turn of the Civil Service Commission to go up. And the Supreme Court said the Court of Appeals is correct. It would be a violation of due process if you find Lucas guilty of grave misconduct, despite the fact that he was only charged with simple misconduct. So for that, he can only be found guilty at most of simple misconduct. After that, we have the case of Civil Service Commission versus Ledesma. This time, the Civil Service Commission is back before the Supreme Court, claiming that the Court of Appeals did not properly apply Lucas. Why? In this particular case, Ledesma was charged with grave misconduct, but she was only found guilty by the Court of Appeals of simple misconduct. So the Civil Service Commission said the Court of Appeals committed an error. Because according to Lucas, an employee could only be found guilty of that charge with which he was held to account. So if he was charged with grave misconduct, then he could only be found guilty of grave misconduct and not anything else. The Supreme Court said, that's not what we said in Lucas. What we said there was that an employee charged with simple misconduct cannot be found guilty of a higher offense. But it does not necessarily mean that if an employee is charged with grave misconduct, then he should not be found guilty of a lesser offense included in that charge. In the case of Lucas, it would have been a violation of procedural due process because he was only notified of a particular charge and therefore he could not have been found guilty of something else because he could not have prepared to meet the issues in regard to the higher offense. But when it comes to one charge with a grave offense, it necessarily follows that in defending himself, he would also have touched upon any other lesser offense included in the grave offense. So, when Ledesma was found with grave misconduct, he or she could be found guilty of a lesser offense included in that charge, like simple misconduct. Now let's talk about, again, liberated women. What would be a good sign to show the world that women are really that independent, not so reliant or relying on men? How about having a baby without a husband? That could be a declaration of independence, isn't it? I only need a baby, not a husband. So I only need a man for that purpose, after which I will dispose of him. So now we have the case of Anonymous versus Radam. And take note of the title because it appears to be quite appropriate. Radam was a court employee and she was charged with immorality for having a child even if she was not married. In the birth certificate of the child, it was indicated that the father was unknown. Is that possible? What is she, a condominium? When she was made to explain, she said that it's true. She has a child, and the father is actually the boyfriend. They decided not to get married yet because the boyfriend is applying to migrate to Canada. And if they got married before then, it might prejudice his chances of having his application approved. So it's okay with them that they are not married. When the Office of the Court Administrator came up with its recommendation, it was for exoneration of Radam. And the Supreme Court agreed. Having a child, even if one is not married, provided that the parties are not under any legal impediments, is not something that is so immoral that would merit administrative sanctions. In this case, Radam and her boyfriend are both single. It's just that they decided not to get married yet. So if they have a child out of that relationship, that cannot be considered as grossly immoral. And therefore, Radam cannot be disciplined simply for that. The Office of the Court Administrator also recommended that Radam should be sanctioned for acts unbecoming, for falsely indicating in the birth certificate of her child that the father was unknown, when all along she knew who it was. The Supreme Court said, sorry, but we cannot agree with you. Why? She was only charged with immorality. She was not charged with having falsely indicated in the birth certificate that the father was unknown. So it would be a violation of due process if she is now found guilty of something that was not charged against her. So that's the case of Anonymous versus Radam, involving an allegedly unknown father. When it comes to appeals, appeal is not part of the guarantee of due process. That means that Congress may or may not provide for appeal from certain proceedings. If appeal is not provided for, that doesn't necessarily mean that there's a violation of due process, because it is up to Congress, because appeal is merely statutory. However, if Congress had provided for appeal and a party is deprived of that, then that would be a violation of due process, because it's already provided for by law, and yet the party is denied access or availing the appeal. Anyway, even if there's no appeal, some review can still be had through the special civil action of certiorari. The only difference is a review by certiorari, not the petition for review certiorari, but simply the special civil action of certiorari would be much more limited, because the issue then would be about jurisdiction. In ordinary appeal, the appellant can have a wrong judgment corrected. So the appellate court can determine whether the lower court committed a mistake in the appreciation of the facts or in application of the law. When it comes to certiorari, however, even if there was a mistake committed by the lower tribunal, but the petitioner cannot show grave abuse of discretion, then the judgment would stand, not because it is correct, but simply because the lower tribunal was not shown to have committed a grave abuse of discretion. So that basically is the difference between ordinary appeal and petition for certiorari. But at least you still get a chance to have the case decided against you, reviewed. So, since appeal is not constitutional and merely statutory, the Supreme Court has also said that compliance with the requirements must be strictly done. Otherwise, the appeal would have to be dismissed. A requirement also when it comes to appeals is that the person who rendered the decision must be different from the person who would now subsequently pass upon the appeal. So how is it possible that the same person would be the one who rendered the original decision and would still be the one to review it on appeal? Well, it has happened in the past. You have that case of Zambales Chrome Light, for instance. Here, the Director of Mines rendered the decision. So the aggrieved party appealed to Secretary of Agriculture and Natural Resources. While the appeal was pending, the Director of Mines became the Secretary of Agriculture and Natural Resources. In that capacity, he was the one who passed upon the appeal. Of course, he affirmed his decision as Director of Mines. So when the case went to the Supreme Court said there was a violation of due process. It's only human nature that a person would now uphold what he had earlier decided in another capacity. So the Secretary should have allowed some other subordinate of his to pass upon the appeal and not for him to personally handle it. A twist to this is the case of Simpson versus NLRC. Simpson was an employee of PAL. He was dismissed by PAL, and so he filed a case against PAL with the labor arbiter. The labor arbiter decided in his favor. So PAL appealed to the NLRC. In the meantime, the labor arbiter became also a commissioner of the NLRC. And he was assigned to that division where the appeal of PAL was pending. When that division rendered its decision, the former labor arbiter concurred with his colleagues. What was the decision? For the reversal of his decision as a labor arbiter. On motion for reconsideration, he inhibited himself, but of course, the other two commissioners simply stood by the original decision. So the case went up to the Supreme Court, and the Supreme Court said there was denial of due process. This former labor arbiter should not have participated at all. What about the fact that he inhibited himself in the motion for reconsideration? Even then, the Supreme Court said because his participation at the start of the deliberations before the commission already tainted the entire proceeding. A more recent application of this principle was found in the case of Tejano versus Ombudsman. And this we have as principal character, Desierto. You still remember the position of Desierto before he became Ombudsman? It's okay. The modern generation has a shorter memory span, isn't it? They try to forget as soon as they learn something, until they realize they need everything that they learned from first year until they would have passed the bar. Before Desierto became Ombudsman, he was a special prosecutor. So as special prosecutor, he was a subordinate of the Ombudsman. And as a special prosecutor, he participated in the investigation of Tejano. That investigation led to a recommendation that Tejano be prosecuted before the Sandigan Bayan. So the appropriate information was filed against Tejano. While the case was pending before Sandigan Bayan, Tejano asked for re-investigation, and this was granted by Sandigan Bayan. So a re-investigation was conducted at the Ombudsman, and a recommendation was made to the Ombudsman that the case against Tejano be dropped. By that time, however, the Ombudsman was already desierto. He disapproved the recommendation and even wrote a marginal note saying that the case should be assigned to another prosecutor who should prosecute the case aggressively. A motion for reconsideration was filed, and it was denied by the successor of Desierto, Marcelo. So the case went up to Supreme Court, and Supreme Court, applying what it earlier said in the case of Simpson, that the participation of Desierto as ombudsman tainted the proceedings, such that even if the motion for reconsideration was denied by his successor, still the same was useless. Since Desierto participated in the earlier preliminary investigation as special prosecutor, then he should not have touched the case when the same went to him as ombudsman, because he, having earlier suggested or recommended the prosecution of Tejano, could not be expected to decide otherwise after he already became ombudsman. So the mere fact that his successor was the one who resolved the motion for reconsideration was not good enough a basis for saying that due process had been served. So that's the case of Tejano. In the case of National Appellate Board versus Mamawak, the Supreme Court said that it would also be violative of due process if an administrative agency or an arm of an administrative agency that is responsible for deciding cases would be the one to now take up the matter if its decision was reversed by the appellate court. So in this case, the National Appellate Board rendered a decision against Mamawak. Mamawak elevated the case to the Court of Appeals, and the Court of Appeals reversed the National Appellate Board. Now, the National Appellate Board went up, questioning the reversal of its decision. The Supreme Court said that's not proper. The National Appellate Board is supposed to be an impartial body that decides cases. So just like a judge, if his decision is reversed, it is not for the judge to be the one to bring it up on appeal to a higher authority. It's up to the other party to do that. In the case of Napolcom, instead of the National Appellate Board, it should have been the prosecution arm of the Napolcom to bring up the issue. In EDI Staff Builders versus NLRC, the Supreme Court said that if a party, the appellee, has not been furnished a memorandum of appeal of the other side, then it would be improper for the Supreme or for the NLRC to subsequently render a decision without any proof that the appellee has been really notified. In this case, EDI Staff Builders was charged before the labor arbiter. The labor arbiter decided in favor of EDI Staff Builders. So, all along, EDI thought that there was no more case because it didn't hear until it was served with a motion for execution. How could there be a motion for execution when EDI was the one who won the case? It turns out that the employee appealed from the decision of the labor arbiter, but he did not furnish EDI staff builders with a copy of his appeal memorandum. Then NLRC proceeded to decide the case even without proof that EDI staff builders had been notified. The Supreme Court said there was grave abuse of discretion on the part of the NLRC in having proceeded to decide the case, notwithstanding that the appellee had not been duly proven to have been notified of the appeal. While the NLRC was not deprived of its jurisdiction over the appellate or the appeal case, still it had no right to come up with a judgment without hearing the other side. This principle was reiterated in the Morrison case of Cayo Lasam versus Ramulete. This one involves the PRC, the Professional Regulation Commission. Again, procedural due process is basically about notice and hearing. If you are given the chance to be heard, does that give you the right to lie? And if you are caught lying while trying to explain your side, could you be sanctioned for what you did? The U.S. Supreme Court, in the case of LaChance versus Erickson, said that the right to be heard does not justify the act of lying. Therefore, if you are caught lying while explaining or trying to defend yourself, then you could be charged separately for that act of lying, and for which you would also be sanctioned additionally. So that's the case of LaChance versus Erickson. In regard to committee investigations, we have the case of Pefianco versus Moral. Moral here was an employee of the National Library, and she was found trying to build her own library courtesy of National Library materials. So a committee was formed by the Secretary of Education to investigate, hold hearings, and make recommendations. After these proceedings, the committee came up with its findings with a recommendation that Moral be dismissed. The Secretary of Education then came up with a decision for the dismissal of Moral. Moral did not appeal from that judgment. And after the decision had become final, she went to court asking the court to compel the Secretary of Education to furnish her, Moral, a copy of the investigation committee report and recommendation. Is that part of the guarantee of due process? The Supreme Court said no. The committee report and recommendation is internal. It's only something between the authority that constituted the committee and the committee itself. If ever, the only entitlement of Moral is to the decision of the Secretary of Education dismissing him. So, if there is any basis for her dismissal, and there is ground for her to appeal, she should have appealed from that decision of the Secretary of Education. The committee report is not part of her entitlement to due process because it is merely internal, something between the Secretary of Education and the committee that he formed. This was reiterated in the subsequent cases of Velasquez versus Hernandez and Viva Footwear versus Securities and Exchange Commission. In regard to bouncing checks, take note that under BP 22, there is a way out for the persons who may have issued a check, which subsequently bounced. And the way out is for that drawer to make good the check within 5 banking days. So what implication would that have for a company official, for instance, who may have signed checks on behalf of the corporation? The corporation itself cannot sign checks, so it would have to be done by a natural person. So let's assume that the treasurer signed a check for and on behalf of the corporation. That check bounced. Notice of dishonor was sent to the corporation, but for one reason or the other, the treasurer was never personally informed. Can the treasurer be successfully prosecuted for violation of BP 22? The Supreme Court said no, because the treasurer was not personally notified. But there was notice to the corporation in which he is an officer. Even then, notice to the corporation would not be notice to the officer of the corporation. So without that notice, then that person could not have avail of the way out as provided in BP 22. And if he was not given the chance, then he cannot be successfully prosecuted. When it comes to promulgation of administrative rules and regulations, you have that old case of Philippine Consumers Foundation, Inc., where the Supreme Court said that administrative agencies exercise quasi-legislative and quasi-judicial powers. Normally, notice and hearing would only be required when it comes to the exercise of quasi-judicial powers. But when it comes to the promulgation of rules and regulations, which partake of quasi-legislative powers, then there is no need for prior notice and hearing, because just like Congress, they may or may not hold hearings before they pass the appropriate legislation. Then came the subsequent case of Commissioner of Internal Revenue versus Court of Appeals. This had something to do with a revenue circular that was promulgated by the Commissioner of Internal Revenue, which provided for the reclassification of certain cigarette brands from domestic to international. So this would have the effect of increasing the amount of taxes that would have to be paid by these cigarette brands. These were brands belonging to Fortune Tobacco, Hope, Champion, and more. Fortune Tobacco, of course, since it increased its tax liability, questioned the validity of that circular because allegedly there was no notice and hearing. The Supreme Court said whenever an administrative agency exercises quasi-legislative powers, the rules that may come up with may either be interpretative or legislative in nature. If it is merely interpretative, then there is no need for notice and hearing. But if it is legislative, there is need for notice and hearing. The revenue circular issued by the Commissioner of Internal Revenue was legislative in nature. Therefore, there was a need for prior notice and hearing. In this case, since there was no notice and hearing, then they could not be considered as effective. In the subsequent case of BPI Leasing Corporation, Supreme Court said that the rule announced in Commissioner of Internal Revenue would not necessarily have to apply if, instead of imposing a burden on the taxpayer, it removes or reduces the burden. Because in that case, it would be more favorable to the taxpayer. So it would only apply if there would be additional burdens for the taxpayer. Now let's talk about cell phones. When did cell phones become generally available in the Philippines? For some, they're already born with cell phones, right? The younger generation will again not have any good idea as to how life was before cell phones were available. So those were the years where you would apply for a landline, and it would take years before a line could really be connected to your house. And then there was even that incident, I don't know if it's true or not, when former Prime Minister of Singapore, Lee Kuan Yew, visited the Philippines, I think in the late 80s or early 90s. And he made a joke about the telephone system in the Philippines. According to him, in the Philippines, it takes years to have a line. And after you would have a telephone line, it would take hours to have a dial tone. He said that in a forum that was sponsored by PLDT. Anyway, that just illustrates the problem that we had before the advent of cell phones. And if you used to have a landline during those times, it's possible that you also had good neighborly relations because of this so-called party line. You pick up the phone, somebody is talking. You return the mouthpiece to its cradle. After 15 minutes, you pick up the line, still the same voices. Okay, put it down again. 30 minutes, still the same voices. So what are you supposed to do? In no time, you'd already be in trouble with your neighbor, right? But what do we have now? We don't have party lines. Instead, cell phones are now sharing one individual, right? So it's that reverse. More and more individuals have two or even more cell phones. One for each girlfriend. And phones are no longer used merely for communication. No longer for verbal conversations. They could even do much more. Something that you can use to record your more intimate moments. And if you're not careful, those moments might suddenly find themselves in YouTube. So, again, this illustrates the fast pace of modern technology. You still remember when you had your first cell phone? Has it been about 15 years ago? And yet, for the modern generation, they might start thinking that cell phones have been there all along. Still remember the first cell phones available? Those big, or as big as women's shoes? Now you have these very small units, but more powerful. So how did, again, developments or the fast pace of these modern means of communication affect the law? We have the case of Globe Telecom versus National Telecommunications Commission. This began as a case filed by Smart against Globe Telecom with respect to interconnection problem. When the NTC came up with its decision, it had nothing to do with interconnection problem. Instead, it was for the imposition of a fine on both Globe and Smart. Why is that? Since they allegedly failed to get prior NTC authorization before they started offering a branch of SMS. So what's wrong with the decision of the NTC? The Supreme Court found that when Islacom, which is a successor to Islacom, Touch Me, isn't it? It was acquired by Globe and renamed Touch Me, correct? So when Islacom initially offered SMS, it asked authority from the National Telecommunications Commission. The NTC said no need. SMS is just a special feature. It is part of the deregulated aspect of the telecommunications industry. Now, NTC says that SMS is actually VAS, Value Added Service, which is a regulated aspect of the telecommunications industry. And therefore, there's a need to get prior authorization from the NTC before the same could be offered. So what's wrong with what the NTC did? The Supreme Court said apparently the NTC became confused, perhaps because of the fast pace of this industry. It still has the same set of rules. Now, it is changing the way in which it understands those rules. So it would be a violation of due process if the NTC suddenly turns around and says that SMS is VAS, which requires prior NTC authorization. Because previously, under the same set of rules, it held that SMS is merely a special feature. If the NTC wants to change the way in which it interprets its rules, it's only fair that it should first forewarn or notify those affected by those rules and not suddenly turn around and already start imposing sanctions on Globe and Smart for not having abided by the rules, when all along they were of the impression that SMS is not a VAS or value-added service. Another reason for alleged violation of due process is the fact that the case started as a complaint with regard to interconnection problem. So how would it now end up as an imposition of fine for failure of the two companies to apply and secure authorization from the NTC? Now let's talk about the creativity of the Supreme Court, something from which you could also learn. Let's again digress into labor law. In 1989, that's not too far away, right? The Supreme Court decided the case of Wenfield. So under that case, if a dismissal is for cause, but it did not comply with the notice requirement, the dismissal would be upheld, but the employer would be sanctioned by the payment of some form of indemnity because of its failure to follow the law regarding the notice requirement. In the case of Wenfield, the penalty was 1,000 pesos. Through the years, the Supreme Court applied the Wenfield doctrine in other cases, but with the constant warning that the employers cannot simply disregard the notice requirement. So, through the years, because employers still dismissed without notice, the Supreme Court gradually increased the amount from 1,000 until it reached 10,000 by the time it was abandoned in Serrano. In Serrano, the Supreme Court said, "We have been repeatedly telling employers that they cannot simply dismiss for cause without complying with the notice requirement. But apparently, employers are not paying attention. Or perhaps the employers wouldn't mind having to pay even 10,000 pesos for as long as they could do away with the services of someone whose place they could no longer tolerate, isn't it? Because every time you see someone that you don't really like, it only spoils your day, correct? So, if you can pay for her absence, much the better. So for the employers, just dismiss, you just pay for the failure to notify. But in Serrano, the Supreme Court said, enough is enough. You cannot simply take the notice requirement for granted. So, in order to make employers take note and pay heed to what the law required, the Supreme Court came up with a new rule in Serrano. And that new rule meant that the dismissal would be ineffectual until it shall have been affirmed by final judgment. So what implication would that have? It simply meant that while the decision or the dismissal would be upheld eventually, in the meantime, the employee would still be considered as an employee of the corporation, therefore entitled to receive his wages. In the case of Serrano, it was dismissed way back in 1991, and the case only became final in 2000. So if you were the employer, you would be paying for 9 years to someone who brought nothing to you except aggravation. If you were the employer, you would now think twice or even more times before you dismiss without notice, isn't it? Because the penalty is simply not that light anymore. But you might ask, Serrano is labor. So why are we discussing it when we're supposed to be talking about constitutional law? Have you figured out? Oh, you're not supposed to be thinking much when you are in review, right? You are reserving your mental processes for those Sundays in September. So here, your minds are more on relaxed mode, correct? If you took a look at Serrano, as reported in this graph, there are about 100 pages. If the Supreme Court simply wanted to abandon Wenfield, 15 pages or so would have been enough. So why 100 pages? The reason is because of the debate between the majority, led by Justice Mendoza, and the minority, represented by Justices Puno and Panganiban, with respect to the issue of due process. Simply put, the issue was is the dismissal without notice, a violation of due process? The majority said no. Justices Puno and Pangaliban said it was a violation of due process. Anyway, the view of the majority is that it is not a violation of due process because, as you very well know, due process is part of the Bill of Rights. And the Bill of Rights is a protection against the government. Therefore, it can only be utilized as against the government. When you speak of due process, you're talking about what the government had done, which might be in violation of your rights. Here, it's a private employer dismissing its employee. So the court said what is in issue is compliance with the notice requirement, pursuant to the Justinian concept of fairness and justice as found in the Civil Code provisions on human relations. So there is no occasion to talk about due process because that is a constitutional guarantee directed at the government. But to Justices Puno and Pangaliban, it doesn't really matter whether it was done by the government or any of its agencies because the concept of due process is increasingly being assimilated also in administrative law and in relations of employers with their employees. But the majority would not have any of that. Anyway, what difference would it make whether you characterize it as a violation of due process or not? It may be that the majority was uncomfortable with the idea of characterizing it as a violation of due process because of the consequence. Would there really be a difference? You have to remember once more that the effect of a violation of due process is to render the decision or the act done as null and void. So if it is null and void, it cannot be ratified or affirmed. Accordingly, an employee who was dismissed by an employer without notice, if that would be characterized as a violation of due process, the employee would be entitled not only to get his back wages, but also to get reinstated. And perhaps the majority of the Supreme Court justices, that is too much of a consequence for that violation. So, the remedy, to consider the dismissal as ineffectual in the meantime, so that the employee would be entitled to receive his compensation until a judgment is rendered validating his dismissal. So there would be no reinstatement. It makes sense? That was in 2000. Were you then in first year high school? It's so hard to compute after 10 years. Everyone wants to feel a little bit younger. You better make the best of your youth by passing the bar now. Then you can grow old in style after that. Instead of growing old because you couldn't pass the bar. What's the passing percentage of USD? Anyway, it doesn't matter for as long as you make it so much better during your batch, right? Come on. That's a challenge for you. I'm never good at flattery. I'm not trying to imagine how you will look like next year. Would you go to the testimonial dinner with an escort? So, 4 years later, we have the case of Agapon. And this time, the Supreme Court decided to abandon Serrano and revert to a modified when field. Perhaps the Supreme Court realized that it might be too impractical or it might not really be that workable to demand so much from the employer for that misstep of not having followed the notice requirement. But more importantly, the Supreme Court was already ready to characterize the dismissal without notice as a violation of due process. So how did that happen? 4 years earlier, the court was so insistent, was so adamant that it cannot be characterized as a violation of due process. And yet, 4 years later, it was willing to now consider it as such. To properly appreciate again what the Supreme Court did, let's go back to the time when Ramos became president. Still remember? Ramos, during the administration of Cory, was a member of the LDP. And it is part of party discipline that whoever is chosen by the party to become its standard bearer would have to be supported by the rest, right? So when the LDP chose its presidential candidate, it was Mitra, not Ramos. So how did Ramos end up president? He formed his own party, Lakas. The same party that is now weakening. The same party that's now being abandoned by almost everyone. So, how do we apply by analogy what Ramos did to the case now of Agapon? The Supreme Court came up with a new concept of due process, statutory due process. So why do you have to do that? Why don't you just say due process in general? Well, there's a practical purpose. By coming up with statutory due process, now you can disengage it from the general rule on constitutional due process. You can still retain the effect of violation of constitutional due process, but you are now free to chart a new course insofar as statutory due process is concerned. How? As we said, a violation of constitutional due process would mean that the act or the decision is null and void. What about violation of statutory due process? Now, with a new concept, you don't have to follow the usual consequence for violation of constitutional due process. So in the case of statutory due process, you now have to take a look at the law involved. And here it is the labor code. The notice requirement is referred to as the due process aspect. So what then would be the effect of a violation of statutory due process or that due process provided for in the labor code? The Supreme Court took a look at the labor code and said, for dismissal without valid, just, or authorized cause, that dismissal is considered as illegal, and therefore the employee is entitled to reinstatement and back wages. That is explicitly provided for in the labor code. How about for violation of the notice requirement? The labor code does not explicitly provide for the consequence of violating its notice requirement. It has this provision for the need of notice, and yet is silent as to what would be the consequence if the notice requirement is not followed. So what did the Supreme Court do? The Supreme Court said the law provides for certain rights. So the mere absence of a sanction, as found in the labor code itself, should not be the end of the inquiry. So it went now to the civil code and found that nominal damages are awarded to those whose statutory rights had been violated. So, since the labor code provides for notice, and if that requirement has not been complied with, it follows that the employee or the worker had that right to notice violated. Therefore, under the civil code, he is entitled to nominal damages. So now you can see again how there could be some hyperlinking. I once read a joke regarding the effect of modern technology on children. Because what the children are aware of now would be the internet and everything else, right? So that child went to a library and he was shown a set of Encyclopedia Britannica. And the question he asked the dad was, they downloaded the whole thing and then printed it. So it's now the reverse. And for many of you, you hardly go to the library now. You just rely on your laptops or computers. Or perhaps pirated copies of Lex Libris. In the future, new generations of students might not even know how this crowd looks like. Anyway, now you have a clear idea as to how the Supreme Court came up with statutory due process as a way to avoid the effect of violation of constitutional due process. In that case of Agabon, the Supreme Court said, we are now going back to Wenfield. But it should not be at the same amount as what was then prevailing at the time when it was abandoned in 2000. So we should make it higher. But it should not also be as burdensome as in Serrano. So the amount, subject to modification depending on the subsequent cases, was 30,000 pesos. Now let's talk about substantive due process. As we have earlier discussed, this would have something to do with the essence of the law itself. We are now trying to determine whether the law could be considered as valid or not. And the general yardstick would be reasonableness. Is it reasonable or not? Is it capricious or arbitrary? In order to have a better view of substantive due process in action, let's discuss it in the context of cases decided through the years. In your first year, you must have come across the case of Bach versus Bell. It has something to do with the sterilization of feeble-minded persons, otherwise known as law students. In that case, Virginia had a law which provided for the sterilization of such persons. And the validity of that law was brought up to the U.S. Supreme Court. the Supreme Court observed that carry back, the person who is supposed to be sterilized and who was then in an institution, was considered a feeble-minded person. Her mother was also a feeble-minded person. And carry back herself had a daughter who was also similarly feeble-minded. So the Supreme Court said it would appear that feeble-mindedness runs the family. It is hereditary. So, if in times of war, men may be asked to sacrifice their lives, asking a lesser sacrifice could also be valid, such as getting sterilized. The court further noted that feeble-minded persons do not really contribute to society. Instead, they become charges on society. So society would be the ones to support them. So if they keep on reproducing their kind, then society might just be swamped with people like them. And it would become more burdensome for society. Therefore, the Supreme Court said that law is constitutional. That was in 1927. 75 years later, or in the year 2525, in 2002, the state that passed the law that was the subject of Bach versus Bell came up with a public apology. Perhaps it realized that what it did was not really that justified. Might be something akin to what Hitler might have been trying to do in World War II when he was trying to cleanse the Aryan race by eliminating the Jews. And then it was also found out that the daughter of Karibak was supposed to be feeble-minded. Actually landed in the honor roll of her class. So perhaps the court was mistaken all along. Anyway, insofar as you are concerned, you may be geniuses, but for as long as you are still to take and pass the bar, make sure that you answer in accordance with currently acceptable answers. You may be correct in your crazy ideas, but if they're not acceptable for the moment, and will only be acceptable 75 years from now, then what's the point? Anyway, you would always have the consolation of passing the bar first, and after that, you can resume your insanity. In the case of Roe versus Wade, we talk about the right of women to have an abortion. How about for men who have been repeatedly jilted? They've shown interest in so many women, and the result has been consistent rejection. If to them life has become useless, can they commit suicide? And if they cannot themselves inflict the necessary step to end their lives, can they ask somebody else to do it for them? And if that person succeeds, can he be prosecuted for the resulting death? In the American case of Washington versus Blacksburg, the issue was about right to suicide or assisted suicide. The U.S. Supreme Court surveyed the laws through generations and came up with the conclusion that there is no such natural right or constitutionally protected right to commit suicide. Therefore, if somebody assists someone to commit suicide and he succeeds, then he can be prosecuted for the resulting death. In this case also, the Supreme Court differentiated assisted suicide from a situation where doctors may now take out the life-sustaining treatment, medicine, or other gadgets for terminally ill patients. So in both instances, death may result. But for those who are terminally ill patients in which the life-sustaining treatment is removed, there would be no criminal liability. So why is that? It's because in the case of assisted suicide, an otherwise healthy individual dies because of the positive act on the part of the one assisting him. In the case of a terminally ill person, you only allow nature to take its course. That person would have been dead long ago were he not kept alive by artificial means. Therefore, if it is his wish that those life-sustaining treatment be discontinued, the Supreme Court said it is perfectly within his right to demand that those intruding things into his body be removed and discontinued. Therefore, if he dies as a consequence of that, then it is only because nature is taking its natural course. So no criminal liability. So that's the case of Washington versus Blacksburg. In regard to the national ID system, you have the old case of Ople versus Torres, where the Supreme Court basically invalidated it on separation of powers grounds, because that administrative order 308 issued by Ramos was quite extensive, and it would now substantially alter the relations between the citizens and their government. So if ever such a piece of rule were to come out, the same should originate from Congress, not from the President, because this would now involve a fundamental policy shift. Another ID system would be in the case of EO 420, which was issued by GMA. But this time, the Supreme Court said that it's well within the power of the President, because it only referred to those in the executive department. So it did not involve IDs issued by other departments, like those issued by the Supreme Court, or even by the independent commissions, like the Commission on Appointments. And the court said an ID system that would require separate legislation would be one that would require appropriation. Here, there's no need, because Congress has already provided for the issuance of IDs by these executive offices. Two, one which would be binding on all the offices of the government, and the citizens would need separate legislation. But here, it's only within the executive department. Also, one that would require the gathering of data that's not otherwise ordinarily provided for. That would also require separate legislation. But here, what the executive order did was to try to make more uniform, to streamline the manner by which information and data is gathered by the different executive offices, so that their IDs and the information they have would be more uniform, more user-friendly, and it would also provide for greater efficiency and economy. A feature of the ID system provided for in AO 308 issued by Ramos, and which was the subject matter of Ople versus Torres, was with regard to its intrusiveness relative to the privacy of individuals. Justice Puno, who wrote the majority opinion, but who was not joined by the majority in regard to that aspect, said that if that or those provisions of AO 308 were to be incorporated in a law passed by Congress, there would still be some doubts about its constitutionality because of that violation of privacy concern. How about in EO 420? The Supreme Court said it does not have the same degree of intrusiveness. And moreover, as already explained, it was more to streamline and make more uniform the data gathering by the different executive offices so that they would not just be doing what they think should be done. Instead, there would be greater uniformity in the different government IDs. So that those are the cases of Ople versus Torres and KMU versus Director General Neda. Now let's talk about marriage and other intimacies. Would anybody among you ever think of getting married to someone who's about to retire? Your smiles say it all, but there's something wrong. Why would anyone enjoy the company of someone who's about to go? In the case of Montes Claros, what was in issue was a provision of the old GSIS charter, which would disqualify a surviving spouse who got married to a GSIS member within 3 years before retirement. So she would be disqualified from receiving survivorship pensions. The counterpart case, insofar as the private sector is concerned, and the SSS, would be the case of the CAICO. In the case of the CAICO, the disqualification would be in the manner in which the term qualified beneficiary is understood, meaning that the spouse should have been married to the SSS member before he retired. In both instances, the Supreme Court said that those provisions or readings of the law would be violative of due process. It would unduly deprive the GSIS and the SSS members, as well as their beneficiaries, of what they are entitled to. GSIS and SSS members contribute to the funds, and they have therefore an expectation, a claim to the proceeds whenever they would now be entitled to the same, including their beneficiaries. Therefore, it's quite arbitrary to deprive their surviving spouses of what they should be receiving when, or simply because they got married late in life. In Montes Claros, the Supreme Court also made reference to the deathbed marriage laws in the U.S., which have been upheld. But the Supreme Court said, in those cases, the point of reference is the death of one of the parties, whereas in this case, the point of reference is retirement. So, for one who is about to die, then it's understandable that someone who wants to marry him may have some ulterior motives for doing that, isn't it? Because now there is an expectancy that within a short period of time, she might even be able to accelerate the process. But in the case of retirement, there is no certainty that just because a person is retiring, he would soon be dying, isn't it? What if, on the contrary, because he got married to someone so much younger, he might have found the fountain of youth. So instead of dying, he would then live up to the age of 90. What would happen to the woman? By the time he goes, he will be too old to be appreciated by younger Johnny, right? So in those two cases, the Supreme Court said the provisions of the GSIS law, as well as the reading of the term qualified beneficiary under the SSS law, would be unconstitutional. They would be violative of due process. How do men, if they are in a relationship with their fellow men, do it? So we have the case of Bowers versus Harddick. Actually, it's spelled with a W. But as you can see, you could very well relate if it's pronounced as D, right? This is a case involving two men literally caught with their pants down, doing what came naturally to them. However, in the place where they were caught doing it, there was a law which penalized homosexual sodomy, which is a relative of sodomy. So they were prosecuted, and they questioned the constitutionality of the law. The Supreme Court of the U.S. said it is well within the power of the state to pass laws intended to promote the good morality of the community. So if to the state, homosexual sodomy is something that is contrary to its idea of good morality, then the state may criminalize the same. Several years later, in the case of Lawrence versus Texas, the U.S. Supreme Court was again confronted with the same issue, and this time the Supreme Court now reversed its holding. It abandoned Harddick. The Supreme Court said that what two consenting adults do in the privacy of their homes is no concern of the state, no matter that it may not conform to its idea of what is right or proper. Since they are two consenting adults, then they are free to express themselves, their affection for one another, in the way that would best serve them, for as long as the interests of society are not thereby harmed or endangered. So, of course, if they're doing it in the privacy of their homes, how would they scandalize society, isn't it? Unless you start going to pig. But that would also be a violation of the right to privacy. In the case of Lagyo, City of Manila versus Lagyo, the Supreme Court borrowed a line or two from Lawrence versus Texas in order to invalidate an ordinance passed by the City of Manila, which provided for the phasing out of motels and similar establishments in the Ermita Malate area. Again, of course, this is supposed to be for the promotion of the good morality in the community. But the Supreme Court said the ordinance in question here suffers from legal infirmity at almost every turn. Why is that? For one, it now absolutely prohibits these establishments in that area. But a local government unit can only regulate what is allowed by national law. So it cannot prohibit altogether that lawful activity. For another, the Supreme Court also said, immorality is not in the face. It is in the hearts and minds of men and women. If you don't have that thought in your mind, how would you make it work? And then the court also asked rhetorically, if acts of immorality were to happen in a court chamber, perhaps that court knows what it's talking about, or in a church cloister, does it mean to say, following the logic of the ordinance, that the city would now have the right to close that court or the church? Obviously not. So it is part of the right to autonomy of two consenting adults without any legal impediments to consummate in intimate sexual conduct their relationship in those premises. If they go to these places, they do not violate any fundamental constitutional policy, and they do not lose their self-respect or dignity. Also, subsequent to this, we had the case of White Light Corporation versus the City of Manila. And this one had something to do with another ordinance along the same lines as Lagyo. This time, the ordinance sought to prohibit the so-called short-time accommodation and the charging of short-time fees. The Supreme Court again said that the law is unconstitutional. Using strict scrutiny, court said that it unduly restricts the rights of the patrons of these establishments as well as the owners of these establishments. There is no compelling reason why patrons would have to pay for much more than they really need the room. And it would not always be said that it is for immoral purposes. The court said during brownouts, entire families might decide to simply go to these places and avail of the amenities instead of sweating it out in their houses. Or for a traveler, you may only need to rest for a few minutes before continuing with his travel. So why do you have to insist that he will have to pay for at least 12 hours stay? The Supreme Court said that ordinance cannot withstand constitutional scrutiny. Now let's talk about embraces. I understand that women enjoy embrace. In the case of Michael H. versus Gerald D., you have here a conflict between a legal fiction and scientific fact. So which prevails? Law creates some presumptions, but this did not always be true. It's only for convenience, and simply because it's borne out by experience. But what if it is now clearly shown that the legal presumption is contrary to what is scientifically proved? Which prevails? One such presumption is the presumption of legitimacy of a child born to a marriage, isn't it? So the husband is presumed to be the father. But it may happen that the wife could get adulterated. So what are they going to do now? In this case of Michael H. versus Gerald D., Gerald D. is the husband. He's married to a former international model. Gerald D. is a busy executive. Therefore, he has to leave the house every now and then, traveling to other places, leaving the wife behind. So in time, perhaps, the wife got bored having to sleep at night, contending with a lifeless and unresponsive pillow. So what she did was to venture outside, and in time, she fell into the waiting arms of a neighbor, Michael H. An embrace produces warmth, right? And if you keep at it, it may become hot. And if you still don't let go, then it may create fire. And that precisely is what happened in this case. That fire was a child. Blood tests up to 98% certainty indicated that the child was Michael H., not the husband's. In time, however, the husband recognized the child as his. And that created a problem for Michael H. Because under the law, since the husband has already recognized the child as his, then that would effectively cut off the access of Michael H. to the child. Now he went to court trying to establish his filiation to the child. But under the law, he cannot do that because it's already precluded. So there is a conflict between the presumption in the law and the scientific fact, which prevails. The U.S. Supreme Court said the legal fiction prevails. But it's not the truth. Yes, even then, because that legal provision is a declaration of fundamental public policy designed to protect and maintain peace and harmony in the family. So, at the rate of occasional error, because of the higher interest of society in preserving peace and harmony in the family, it may be that you could now have the legal fiction prevail over the scientific fact. Anyway, you could just imagine what would happen if the husband, having recognized already the child as his, would now be confronted with a stranger coming to the house and saying, "That's actually my daughter." So how would the husband feel? Whereas if you now say, back off to that biological father, then he would not be going to disturb the peace and harmony in the family. So it somehow makes sense. In regard to imprisonment, imprisonment is normally the penalty or violation of a criminal statute. And imprisonment has a term. Can a person sent to prison be made to stay behind even after he would have served the term for which he is supposed to stay in jail? The answer would, of course, be immediately no. Because that would be a violation of his right. He is supposed to be free already. But in the U.S., there are certain laws which allow for the continued confinement of certain criminals, even after they would have served their terms of imprisonment. So we have that case, for instance, the case of Kansas versus Hendricks. He was charged and found guilty of molesting children. So he was sent to prison, and towards the end of his stay in prison, he was interviewed, and he admitted that if ever he would be released, he would not be able to prevent himself from molesting children again. So because of that admission, he was made to stay behind. And the issue now is that law constitutional? The Supreme Court said yes, because you do not consider his continued stay as still punishment. He is now made to stay because he is sick and therefore needs to be treated, or at least he would have to stay there until he would have cleansed himself of that desire to molest children. Because if you were to release him after he would have served the number of years that he's supposed to be in jail, then you would now be exposing the children in the community to the possible molestation again by this person. So, to protect the interest of the community, you may have to confine him further. Anyway, it's no longer as punishment, but as part of an attempt to trick him. So that's the case of Kansas versus Hendricks. Still on due process, you have the so-called void for vagueness doctrine. Under this doctrine, if a law is so imprecise that people of ordinary intelligence would guess as to its meaning or differ as to its application, then there must be something basically wrong with that law and therefore must be declared void. Perhaps we can simplify this by relating it to your classroom experience. Assuming that your professor asked a question that could be understood in several ways. Of course, you would have to answer it in accordance with how you understood the question. So if you understand the question one way, your seatmate understands it some other way. Some other classmates of yours would also understand the question in a different manner. And worse, you understood the question in a manner which is not in accordance with how your professor intended it to be. So you come up with your answer based on your understanding of the question, and your professor would now shout at you, "Wrong, stupid." It's not your fault. Obviously, it's not your fault, isn't it? Because if the question could have been framed in a proper manner, such that there could only be one way of understanding the question, then you would have answered it in accordance with that meaning. But if it is capable of several interpretations, then obviously you could come up with several answers. So in the same way, in regard to this so-called void for vagueness doctrine, if a law were so imprecise that people cannot have a readily agreeable understanding of that law, then it should be declared void. It would be unfair because the people are supposed to comply and abide by the law. But how would they abide by a law that they could not readily understand? If you do not know what the law really requires, then you would not be able to do what the law wants you to do. And moreover, that kind of a law could be oppressive insofar as the affected individuals are concerned, because they could be utilized by the government authorities to unduly discriminate or otherwise prejudice the public. There could be discriminatory prosecution or arrest. You understand it one way, and you think that what you're doing is perfectly innocent. Then a policeman would arrest you. Of course, you will not understand why all of a sudden you're getting arrested by the policeman. And the policeman would say, "You violated this law." But according to your reading of the law, what you were doing does not fall within the ambit of that law. But if it is vague, then the policeman can say, "That's how I understand the law. You violated it. Therefore, I'm going to arrest you." So you can just see now the kind of prejudice that an ambiguous or vague law can bring about to the people. Presently, the Supreme Court is not yet definitively settled with regard to the idea as to whether the void for vagueness doctrine is a dictate of due process or is only applicable in free speech cases. In the old case of Romualdez versus Sandigan Bayan, that debate between the majority of the Supreme Court and Justice Tinga came up. The majority said that the void for vagueness doctrine is specific to free speech cases. Justice Tinga said no, it's more dictate of due process, and came up with a very scholarly and extended discussion. But at that point, it was all by his lonesome. Then another Romualdez case, Romualdez versus Comelec, decided several years later. This debate again cropped up. Again, Justice Tinga came up with his arguments, and this time he was joined by some members of the court, including the Chief Justice, and I think including also Justice Carpio Morales. What's more, Justice Carpio came up with his own separate opinion along the same lines as Justice Tinga. And I think their position is better compared to the majority, because their position is well reasoned compared to what the majority is saying, which is basically a repetition of what had been said in the past without much discussion as to why it should be specific to free speech cases. Being informed, being confronted with a law that you can easily understand and comprehend, that appears to be a matter of due process. It's a matter of fairness that you be notified as to what is allowed or what is prohibited by the law. So what is specific about free speech cases in that regard? As a matter of fact, in American cases, there's nothing that refers specifically to free speech cases as the domain of this so-called void for vagueness doctrine. I think there's some special announcement that Al would tell you, so we'll just continue with our constitutional law next week.